Our legal panel. Anna Yum is a former prosecutor and criminal defense attorney. Emily Campagno is a former federal attorney and former criminal defense attorney as well. Thanks, both of you, for being here. Anna, does the state of California have legal ground to stand on here?
Potentially they do. I mean, here in the state of California, I think the primary legal argument is, as you had indicated, that the federal government is usurping Congress's authority in terms of federal funding authorization and appropriating federal funding. I think another primary argument that the state of California is relying upon is that this is the federal government's backdoor attempt in trying to enforce immigration by using local state authorities and local law enforcement to do that. And the state of California is essentially saying, this is not our job. Our job is to protect the citizens of the state of California, not to implement immigration enforcement. And I think the primary argument is going to be a highly contested issue here with the state of California versus the Department of Justice.
But Emily, as you well know, the federal government often uses money to try to strong-arm the states. There was that flap a few years back when the federal government said to all of the states, raise your drinking age to 21 or we're going to withhold federal highway money, and that was upheld.
You're exactly right, John. And the two specific arguments that California and the city of San Francisco are making here don't hold weight. So the anti-commandeering statute does not protect sanctuary cities or states in this instance because it doesn't protect when Congress is merely requesting information. And then for the anti-coercion doctrine, this does not hold weight either because courts have construed that doctrine in this arena to mean 20% of the budget, meaning only when Congress is threatening up to 20% of that entity's budget is it coercion. Now let me give you some statistics. The city of San Francisco's annual budget is $9.3 billion. That is greater than 10 states. They're facing in question only $1 million. $74 million of their annual budget goes to their attorneys, the city attorney's office alone. State of California has an annual budget of $183 billion. They are only facing $28 million. And note, they just designated $50 million of which to defend illegal immigrants facing deportation. So there's no way that the monies in question is rising to coercion at all. Remember, 80% of taxpayers who also contribute to the budget support the notion of an illegal immigrant convicted of a crime being turned over to federal authorities.
Let's talk about $28 million that California relies upon by the federal government this year alone for law enforcement grant money. And so when we have to be mindful about the potential for backfire and also unintended consequences here. The federal government is requiring that state local authorities give them 48 hours notice before releasing any undocumented immigrants. And if that's the case, inevitably that's going to result in overcrowding of jails. Because if we have to keep at least 48 hours illegal immigrants in our jails, then what's going to happen to the overcrowding of the jail system, which is prevalent here in the state of California? Does that mean that other dangerous or violent criminals are going to be released because of that 48-hour mandate? Who draws that criteria and who is going to accept that? Who is going to decide that? Not only that, what about the illegal immigrants who could potentially serve as key witnesses in dangerous and violent crimes? Does that mean that the prosecutors, the state prosecutors, are going to have a more difficult time in securing convictions because illegal immigrants are scared about testifying and are scared about being deported?
Those are some of the arguments.
These are things that we need to be mindful about.
Yeah. We're going to ask our legal panel to stay right there because we have another big story we want to get your reaction to. A new Justice Department warrant requesting personal information on visitors to a website that was used to organize protests against President Trump on Inauguration Day. That when we return. Back with our legal panel, and right now a web hosting company is challenging a warrant from the Justice Department. The warrant requests information on visitors to a Trump resistance website. The warrant requests the company, DreamHost, provide over 1 million IP addresses, those are computer addresses, along with other information on visitors to the website, which was involved in organizing protests against President Trump on Inauguration Day. Let's bring back our panel, Anna Yum and Emily Campagno. So the federal government is saying, look, we want information on these people who were obviously interested in joining the Trump resistance movement, at least on Inauguration Day. That website, DreamHost, is trying to turn this down. Emily, do they have legal standing?
They do not. So they're making two arguments. They're saying that the language is too ambiguous, it's uncertain, and that the information requested is protected. Now, the function of a judge when determining whether or not to issue that search warrant is to determine whether the language is in fact specific enough. Here, the search warrant was issued, which means it suffices the particularity requirement. Secondly, DreamHost argues the Privacy Protection Act is what protects that information, but the exclusive remedy for violations of that act is a civil action for damages. It's not complying with a search warrant lawfully issued by a judge. And remember, a search pursuant to a search warrant is presumed lawful.
Anna, the judge did issue this warrant. There had to be some pretty good information behind it.
Well, of course, you can always challenge the issuance of a warrant and challenge the validity of the warrant. And I think that the company's main argument is that the federal government is overreaching. I think their main concerns is that there's a potential slippery slope argument, because if you allow this to happen, what else are you going to try to get in terms of the federal government? Does that mean that phones are going to be on limits? Does that mean that the federal government can start searching people's houses? And of course, another argument that you have to consider is the potential chilling effect. The intention of the First Amendment is to promote and to encourage the freedom of speech and freedom of expression. And if the federal government is asking for 1.3 million IP addresses in addition to biographical information, people are going to be just discouraged from making comments on the internet or looking at different websites for fear of potential retaliation or for fear of the federal government retrieving information about them. So I think it does raise some very interesting legal arguments, and I'm excited to see what's going to happen.
Emily, very quickly, they're not only looking for the IP addresses, they're looking for content of their emails, photos, anything else they might have posted. Is that not overly broad?
Well, I respectfully disagree with the logic of a slippery slope argument when protesting any type of search warrant or any topic for that matter. The function of the courts is to have a closed universe and to receive and to ensure that precedence is followed. So here you can't argue with the fact that the PPA does not allow for this remedy, number one, and number two, that the language is in fact specific enough to have it be a lawful search warrant and thus particularized information being sought by the DOJ.
We will continue to follow that case and let our viewers know what the courts decide. Emily Campagno and Anna Yum, thank you.